welcome to another episode of War and Words, a podcast by the Conflict Law Center. Today, we are very, very happy to have with us Rebecca Mignot-Mahdavi, who is an assistant professor at Sciences Po Law School. She is also the editor of the Leiden Journal of International Law and a research associate at the TMC Asser Institute and the International Center for Counterterrorism. Thank you so much for being here with us today.
Thank you so much, Ayesha. Thank you to you and your colleagues for the invitation.
And so we're here today to talk about your book, Drones and International Law. And I had a great time reading this book. And it's something that we talk about so much in Pakistan, especially, in our context. Drone strikes have been such a huge issue. And it was so interesting to look at it the way you do from a techno and a legal background. And I just wanted to invite you for our audience to talk a bit about the book, and then I can ask you some questions about it.
Sure. So first of all, I want to say that it means a lot to have a conversation with you all, because you're quite you have an acute understanding from where you are also of the different phenomena that I'm interested in the book. So this conversation really means a lot to me, and I'm very much looking forward to having your thoughts also on the different reflections that I share in the book, which indeed is called Drones and International Law, Techno-Legal Machinery. And it already gives indication about the understanding that I have of the phenomenon, that is a combination of technology and legal narratives and legal interpretations that together create different phenomena that I'm looking at. So in other words, in the book, I rehabilitate the power of technology also in our legal understanding. It started with a frustration that in looking at legal scholarship on drones that is really built around the idea that drones are solely a tool and that it all depends on how we use it. So I'm not adopting an overly deterministic approach. So I'm not at the other end of the spectrum, but I'm trying to show that when technology and legal narratives are associated at a certain point in time in a certain context, the counterterrorism context, it leads to a certain reality. It manufactures societies, bodies, behaviors in a way that wouldn't exist without this combination of technology and legal narratives. So very concretely, what I'm describing by compiling very different sorts of materials that I would describe as empirical materials as well, because I'm telling different stories that I gathered from multiple sources. What I'm showing is that this techno-legal machinery is built around the objective of anticipation. And this objective of anticipation extends warfare in time and space, but is also one that institutionalizes warfare. So I'm looking at how the drone program in the US, but also in similar ways in France, has been stabilized in the normal functioning of the state. And then once we've described that the drone programming is institutionalized, the question is, so what does it create? How does it impact societies? Again, bodies, behaviors, etc. And then I'm talking about how this can be translated or conceptualized as rituals of sovereignty. So I'm looking at how the drone program, this techno-legal machinery, infiltrates bodies and societies and affect them in a way that equates an extension of state power in a sense. So I'm conceptualizing it as rituals of sovereignty, arguing that, also based on a Foucauldian reasoning, arguing that, in fact, drone programs, when considered in their entirety, so not looking solely at targeted killings and signature strikes, but looking at the surveillance apparatus that they create, exercise or can be characterized legally as exercises of elements of governmental authority and public powers using the human rights courts, regional human rights courts vocabulary. And under this reasoning, these rituals of sovereignty could trigger jurisdiction of the operating state, or I argue jurisdiction could be recognized. So this is in a nutshell the book. I'm sure we'll unpack this together, but I think, yeah, it's a way to start the conversation.
Yeah, and I think these are all such complicated things going together in terms of, and my focus on it really was from the international law perspective. And there were so many things that, if I've been working in war law and teaching it for a while now, that I realized, oh, this is such a contested area of the law, and the gray areas of it are something that are so used by states. And I thought it was very interesting that you looked at the French perspective, because that's something that has never been highlighted. We always look at the US and the UK one, and they're the French very broad reading of a threat is something that I thought was very unique to this book particularly. And when I finished the book, I truly agreed with the ending of the foreword, which I really, really loved, which was, do we need another book on drones? Yes, we need this one. And it was interesting because it was looking at it from all of these various different aspects and different lenses. And I really, what really struck home to me was that it's not my fault that I don't understand legal justifications for this. Like, they're on purpose very inflating of the jus in bello and the jus ad bellum. And so even as someone who looks at both of these areas of law, it's very difficult to understand. And so do you think that this is a purposeful thing that states are trying to do in terms of fog the law? As they say, we call war the fogging of the law anyway, but to fog the law some more in as it applies here.
Yeah, so there are many interesting points that you raise here. First of all, indeed, the absorption from France of a US rationale, a very sophisticated US legal rationale that has been built under the Obama administration. I'm not so much trying to make prognosis on exactly what was the intention behind this admixture between jus in bello and jus ad bellum that was created. However, in my different discussions with several actors that are interviewed, I understood that this admixture was triggered around 2013 when the US implied that in the presidential policy guidance that they would focus almost exclusively on the right to self-defense. And this, I understood in my conversation, that it had to be read in light of the diplomatic ambitions of this presidential policy guidance to respond to a concern among allies of various members of Congress as well, but of allies and within the US regarding the compliance with international law. So the jus in bello framework and how it could echo the Bush framing of the global war on terror was really making allies suspicious, and I think they were left very unconvinced by the framing under the jus in bello umbrella. So we saw that there was somehow a shift in the narrative, and I think turning to the jus ad bellum punctual uses of self-defense, although we can see that an accumulation of jus in anticipatory uses of force in self-defense against individuals showing signs of belonging to a group kind of equates the jus in bello paradigm. So therefore, then the confusion was created, but I think it was a diplomatic strategy, and it worked. It worked when you see that the signature strikes that were conducted by France in the Sahel region, now we've been kicked out, so the question will be less topical, but the signature strikes that were conducted that led to civilian casualties in Mali, for instance, in a village called Bunti, on a wedding that was wrongly characterized as a gathering of military-age males. Very similar to some events that took place in Pakistan. is built around this notion of anticipatory self-defense with an admixture of use and bello. So I see what you mean, and I really share your intuition that it kind of also hits two birds with one stone. So on the one hand, we convince allies that we have sophisticated legal narratives to make our uses of force plausible. And on the other hand, it kind of happily confuses the different legal frameworks that are applicable, and therefore it's somehow easier to swallow. I share this intuition that you have.
I thought it was so interesting and quite I thought the saddest moments of the book, really, for me, aside from, you know, the civilian loss of life and damage, was really the behavior change that you went into, in the sense when you were saying that, people actually stopped sitting in jargons because they were like, that would make me right for those types of signature strikes. They were changing their behavior so that they wouldn't be vulnerable to such strikes. And I thought that you're recounting, there were a number of strikes that you recount in your book, but the one of Bassem Razzo really stood out, and I copied and I wrote it all down in my notes, because this man was sat there reading car reviews, and that singled him out for a strike in terms of they believed he would then be the head of a factory making car bombs. And it just showed how faulty the intelligence is in determining whether someone is directly participating in hostilities or, having a continuous combat function, and how legally there is so much confusion. Like, there is so much ink being spilled over what these terms mean and how they kind of apply in practice, and how exploitable they really are.
Yeah, no, I on the stories I tell, I also share with you the feeling that they are probably cornerstones of the book, and this is what I was hoping for.
Yeah.
I really am very sensitive to my own positionality. I'm sitting in Western institutions, well-funded, and I've been sitting throughout the research project in this kind of settings. So I couldn't envisage this intellectual endeavor without putting at the core of my work stories and lived realities that echo or that reveal the impact of the techno-legal machinery that I was describing. So first of all, thanks for highlighting this in this conversation. I think, so you talk about faulty intelligence and the impact of faulty intelligence. I think it shows two things. It does show, of course, cultural misunderstandings as well. So a misunderstanding of the traditions and rituals that are taking place in different settings. So you mentioned the strike on Bassem Razzo's family. We could go back to this strike in Mali, in Bunti, which hit this wedding because they weren't drone operators saw as suspicious an unusual gathering of men, while they were not aware of the fact that weddings take place in this Peul village. They take place with women and men separated for a while before they gather again. So again, there is, rather than faulty intelligence, I would say a cultural gap and a belief in the machine. So this is where the technology comes back, I think. So the belief that the machine, that the surveillance apparatus of the drones allow them to understand and anticipate threats is something that really leads to this kind of situation. So and it allows us to make links also beyond drones with other types of surveillance apparatus, be it domestically at the border or in situations of armed conflict. So to draw some conclusions and lessons from the book for more broadly surveillance apparatus that are based and revolve around machines in which there is a strong belief or trust.
Right. Yeah, exactly. And I think going back to it from a legal perspective, it was very interesting to explore what that meant in terms of NIACs as a non-international armed conflict, what it meant to be a continuous combat function versus a civilian directly participating in hostilities. And we see that quite a bit. Even it actually made me think a lot, because we're quite guilty of doing that with the TTP, so the Tehreek, the Taliban Pakistan, because even though right now they're a cohesive group again, and that's why we've seen a resurgence, but in the past they were a very fractionalized group, and we were like, oh, but we can look at these in terms of an umbrella under the TTP, and does that give more of a license for the state to use force against them? And you looked at that under Al-Qaeda, especially when it came to the authorization to use military force, and you're looking at it in terms of how can we merge all of these together in as part of the same umbrella group, when they're actually different non-state groups. Maybe ideologies are the same, maybe they're saying the same things, but that happens across history. But how does this widen the ability to use force against them? And in terms of, because you also looked at this geographically, and which law applies. So when does IHL apply? When does human rights law apply?
Yeah, no, there are many very interesting points again in your question comment, and thanks also for sharing a different case study that I didn't take into consideration in the book. So indeed, what you see both in the case of the US and in the case of France, even more so in the case of France, which is why also this case study is interesting, is that they use in France the umbrella term that has been used so far is the war against jihadist groups. So it goes beyond the Al-Qaeda and associated forces paradigm, which at least kind of forces to demonstrate that there's some sort of association that allows to fit a new group into the umbrella term Al-Qaeda and associated forces. What is then interesting for me to demonstrate from a legal perspective is how indeed the IHL norms have somehow a disconnect between the characteristics to demonstrate that a group is a non-state armed group under IHL. So when we observe or we try to classify the conflict in the first place, and then throughout the life of the conflict, there's no clear requirement that there should always be a demonstration that the group is sufficiently organized and that the intensity of violence is sufficiently high to maintain the NIAC characterization. So this is on the one hand, and on the other hand, the strikes can be conducted on analysis of behaviors on the basis of either direct participation in hostilities or direct participation in hostilities as continuous combat function or continuous combat function. So the examination of the legitimacy and the legality of the strike is based on individualized or individual characteristics rather than reattached to the characteristics that relate to the group. Of course, this is not to say, so I'm saying that this is exploited by states active in the war on terror, this mismatch somehow, or this unclarity about the rules governing how we approach groups and individuals in situations of armed conflict. So these blurry boundaries and blurry requirements have been exploited. This is not to say, and I want to stress this because it's not something I've done in the book, because it was not its purpose, but of course in the IHL toolbox, there are ways in which, depending on your agenda, and if you want to advocate against this use and exploitation of either legal gray areas or legal creatures such as the continuous combat function, there are tools in the IHL toolbox in order to counter these legal narratives. So there are arguments to say that there should always be attention paid to the fact that the group is sufficiently organized in order to consider that we are at war against this group. There are tools in the IHL toolbox to argue that there should be a characterization of the conflict for each group against which we are at war, etc., etc. So this is just one point that I wanted to stress. I'm not sure I have fully answered your question, though.
No, that was great. Sorry, I was having some technical issues during that, but no, that was a really great understanding of it. Also, in terms of I'm wondering if I came across an Emily Crawford article which talks about how IHL actually encourages the proliferation of drones, and the fact that it's inherent in IHL to kind of use these tools and to claim that they do comply further with IHL. And particularly, I was so horrified when I learned about the Hellfire R9X missile, and I think that was the one that took out that was the one that did the balcony strike. I think it's on Al-Baghdadi. So they don't explode on impact, but they shred the victim, and they have 6 swords in them. So do you agree that they are a mere tool? Because I think that you critique that in the book, the use of drones as a tool and merely a tool. As in, it is about the intel which goes into making them. Drones are just drones. They're a weapon like any other. Or do you think that the system of their use is inherently tied into how the weapon is wielded, how the weapon is used?
Yeah, so this is, of course, a core question in the book and more generally in my work, looking at different security practices using new technologies. And you spotted well that for me, there is a tendency that I think I distinguish myself from in the legal scholarship, that approaches tools as new technologies as mere tools that just a ways for human beings to govern them and to regulate them. So I'm not on the other end of the spectrum, as I was saying initially, arguing that we are being ruled by new technologies, or that, so I don't have an overly deterministic approach at all. However, I do really believe that new technologies emerge in societies in different contexts that make them prone to certain uses, to certain military strategies or different security strategies that lead to phenomena that deserve to be understood as the product of technology. So, including of technology. So I have a bit of an actor network theory approach to these questions, where I really understand all the human and non-human actors as part of an assemblage that couldn't be disentangled from the involvement of these different actors, human and non-human actors. And this probably, I think this tendency in legal scholarship is very revealing of something quite common and banal, that the lawyer thinks of herself as a solutionist, right? We are here to fix things, to fix the world. So technologies are objects that we can rule and regulate. It's a very modernist and scientificist approach that lawyers have generally to objects that they study and upon which they want to act. So it's just, again, it's a case study of a very modernist attitude in international legal scholarship, I believe.
Mm-hmm. Okay, that's a very interesting way of looking at it. And I think especially given the examples that you've mentioned in the book, when it comes to drone strikes in Pakistan, especially, we haven't really had one from since, I think, 2015, 2016. So this was a question which was at the forefront of what we were doing maybe 8 years ago, but it doesn't seem so relevant now. But when we look at it in the context of a global battlefield, or even what Pakistan is doing, what global South countries are doing, drones are not going anywhere at all, and they're looking likely. You can now buy them on Amazon very cheaply. Non-state groups are arming them in their own way, and so they're really going to be so much more intense on the battlefield going forward, especially given their use by states and non-state groups. So that's also why I thought your book was so incredibly important, and it's such a good chance. And it really exposed for me the gaps in my own knowledge, because then I had to sit down and be like, what does continuous combat function actually mean? What does directly participating in hostilities actually mean? And I think that's why I really enjoyed reading it. And I will be, you know, putting it on my syllabus if I'm teaching more law again, and encouraging my students to read it. So thank you so much for taking out the time to talk to us about this very, very important subject and your very, very important work.
Thank you so much, Ayesha, for your invitation. Thank you very much, and for the great questions as well, and for the discussion.
And thank you to everybody watching at home. We hope you'll tune in for future episodes. Thank you.